फर्स्ट आइटम जो है सप्लीमेंट्री के बाद ऑर्डर्स केस करेंगे, नोटिफाई भी कर दीजिए.
From the daily list under heading for mediation for the nationwide 2.0, item 65, second appeal 462 of 2017.
Yes. Other side?
Yes.
With the consent of the learned counsel for the parties, the matter is referred for mediation. The parties are directed to appear. The parties undertake to appear before the Secretary Jhalsa on बताइए डेट बताइए.
After 2 weeks.
After 2 weeks. On 25th of February at 11 a.m. The
Time may be extended to 1 since the party has to come from Delhi.
on first.
1 p.m. time.
Okay, 1 p.m. On 1 p.m. the learned secretary shall appoint a mediator for the parties. Let this order be communicated to the learned secretary Jhalsa.
From the supplementary list under heading for hearing, item 1, second appeal 626 of 2016.
Before I begin, I must concede that your losses were in the last day absolutely right, that there was no staircase for which the right to staircase is unconceivable, but out of record because I have some conditions. That much is because in plain the whole claim in the plain is on the basis of the gift, and if in the gift deed there is no staircase, the question of does not arise along the staircase, but there is a passage. Absolutely, there is a passage.
Passage to the staircase. Passage to the staircase.
Yes. Passage is mentioned, gift deed and the Naksha as well as there is passage.
No, let's take it. It is a passage to the staircase.
Yes, Lord. And the passage is there.
That passage has also been sold.
Yes, Lord.
It's a part of your sale.
Yes. The passage is not has been the subject matter of the gift deed.
Yes.
It was not prior to the sale. हम इसमें दो चीज दिखाएंगे और एक सेक्शन.
कौन सा सेक्शन?
Section 48 of the transfer of property. सबसे पहले प्लेन का पैरा 4
रिकॉर्ड
पैरा 4. परमिट मिल खाली पैरा 1 और 5 को अगर 1 को भी प्लेस का परमिट दिया जाए तो मतलब 5 1 में ही सारा क्लेम है. द बेसिस नॉट द गिफ्ट डीड इज द basis of the claim by which I have considered before the lawsuit. 1 and 5. May I know? That the plaintiff and at all times hearing after one was possessed of plot number 507A having an area of 334 square feet and a house thereon with one roof, one veranda and a right to use and utilize common place, right to enter the common place, right to enter into the courtyard and a right to go up and down through staircase to the roof wall marked in the sketch map by virtue of the gift deed dated 6/7/1981. This is the prior gift deed prior to the sale deed. Amount executed by one Tara Devi, widow of late Janak Thakur, resident of Hari Kisum Shah Lane, ward number 7.
प्लेट दिखाइए आप उनको, आप प्लेट रिकॉर्ड दिखाइए. प्लेट दिखाइए, ये लिखा है प्लेट गलत लिखा है.
अच्छा.
fruits shall I begin from first para 1?
No, I have heard it. It's
Okay.
okay.
Para 1, the basis, the entire claim was the basis of the sale, the gift deed.
So whatever is there in the gift deed, you are only concerned with that.
Yes.
Para
Now,
five.
para 5 is of the. This is the cause of accept. That the defendant obstructed by words on 18/11/2000. The date is very much important. And it is obstructed by the plaintiff, obstructing the plaintiff the use of the said common passage, entering into the courtyard and using the staircase to go up to the roof. Not fine. अब now look, इसमें अब जो इससे related जो हम second दिखाना चाहते हैं, that is DT.12.02.2026, the defendant witness lord, who is lord one of the power of attorney holder on behalf of this Salochna Devi lord, who has
He admitted it. He admits it.
Yes, ma'am.
तो ये तो देख ली.
वो कहते हैं पैरा 29 में कि मैंने उस दिन उस पर्टिकुलर डेट
Yes, yes, he admits it in his evidence.
Yes.
There is no doubt on that.
there is no doubt.
There is no doubt that on that day he obstructed.
Yes,
In his cross-examination, he admits.
yes, पैरा 29 that is specific.
That I have seen.
हुजूर को वो दिखाता है, it means that there was a passage and it was obstructed by law and the passage was gifted by virtue of gifting.
Passage was not gifted. Some easement right was granted.
Yes. Now look, section 48 of the transfer of
Easement right is a transfer.
I mean permitted. हम सिर्फ से गिफ्ट डीड में बोल रहे
नहीं, हम
हैं.
आपसे एक सवाल पूछ रहे हैं, छोटा सा सवाल. Easement right is a transfer. Two things. As per the gift deed, is it an easement right or it's a transfer?
It's a transfer
As per the gift deed.
as per the gift deed.
So you are claiming that you have right, title, interest and possession with respect to the passage.
It's not as per the in view of the gift deed, not because the gift deed not that particular interest has been not.
You see, there are two things. One is transfer of title and other is grant of some right, so-called easement right. Is it a transfer?
It's not gift is the transfer.
Gift is a transfer, whether this particular clause in the gift deed that you will have right to go through the passage and access the
That is a transfer not which is very much important evident from the recital of the gift deed.
so you say that the passage to the staircase has been transferred to you by virtue of gift deed.
Yes.
You have a title over the passage.
Yes. Yes. 6 and 40.
Title over the passage. To staircase.
Towards the staircase. There was no staircase in the gift deed. Basis. जो भी उसमें गिफ्ट डीड का नक्शा है ना, नक्शा मौजूद है.
Yes.
That is not priority of rights created by transfer, where a person purports to create by transfer at different times right in or over the same immovable property, and such right cannot all exist or be exercised to their full extent together. Each later created right shall, in absence of a special contract or reservation binding the earlier transferee, be subject to the rights previously created. The gift deed lot has been not created previously from the sale deed lot. Therefore, according to the section 48 of this Transfer of Property Act lot, the gift deed is to be taken into consideration first lot, because once the right has been sold to her son lot, the original lot, the donor,
Right has been. Yes.
donor her अपने son को दे दी गई. So milord she has no right to transfer it to subsequent through subsequent sale. So
That sale is under challenge.
milord,
The subsequent sale is under challenge.
they have also not challenged our gift deed.
They will not. Why should they challenge your gift deed?
Because Lord,
Because the case is of easement right.
because Lord, my Lord may see Lord, because Lord, the right Lord, according in view of section 48 Lord, it is to be Lord section the prior deed Lord, the prior.
Now you
transfer-
tell us one thing. Your arguments, is it within the contours of the substantial question of law framed? If it is not, I will not hear it. It's a waste of time.
Lord, that prior court also.
I want to know that is it covered? It is covered under which substantial question of law?
Lord, हमको तो substantial question of law frame करने ही नहीं दिया गया।
आपको क्यों दिया जाए?
उनका जो which is involved.
वकालत नहीं सिखा
This is
सकते
the principal
The
underlying.
law is settled that second appeal is to be decided on the substantial question of law framed.
Yes.
Your argument on section 48 and your argument that you are the title holder of the passage is covered by which substantial question of law? And has the learned courts given a finding that you are the title holder of the passage and the staircase? Title has been decided. Did you seek a declaration of title with respect to the passage and the staircase?
My lord, it may be seen Lord, जो ट्रायल कोर्ट का जो अपीलेट कोर्ट का जो फाइंडिंग है जो उस फाइंडिंग में स्पेसिफिकली आया है कि that right was perfected by Lord because of the gift deed Lord. ये फाइंडिंग में आया है
आप हमको बताइए आपका जो सेक्शन 48 का आर्गुमेंट है कौन सा सब्सटैंशियल क्वेश्चन ऑफ लॉ से कवर्ड है?
मेरा प्रिंसिपल ऑफ लॉ से कवर्ड।
प्रिंसिपल ऑफ लॉ से कवर्ड होने से अरे भाई आप वकालत ये कॉलेज में चले जाइए आप अभी। You are at the stage of college right now. Once you say that you can argue anything you want to, you tell me under which substantial question of law this particular argument is covered. I will hear it. I'll hear it throughout the day. Under which substantial question of law this argument is covered.
With the losses permission,
बस अब हम आपसे कोई सवाल नहीं पूछेंगे। आपको जो आर्गुमेंट करना है you conclude.
If it is not covered by substantial question of law, and if the lordship thinks fit that the section 48 argument is involved in the present case, since there is two deeds, one the gift deed and the sale deed, by virtue of section 100, your lordships may always raise a substantial question.
I am not satisfied that any such substantial question of law is involved in this case. That's enough.
Now let's say I submit something on section 11, sir.
नहीं आपको आर्गुमेंट करने से नहीं रोक रहे हैं, लेकिन आर्गुमेंट विद इन लॉ एंड विद इन द कंटूर्स ऑफ सेकंड अपील करें। आई एम नॉट स्टॉपिंग यू फ्रॉम आर्गुमेंट। ऐसा नहीं है हम सारा एविडेंस पढ़ के आए, ऐसा नहीं है। आपको बता दिए ना, आपको PW7 हैज एडमिटेड that he stopped you on that particular date. That is an admitted fact on that. There is no doubt on that.
There are 23 of the PW7
I've seen it.
सीढ़ी के बारे में भी बोलते हैं।
हाँ ठीक है वो सब कुछ बोलते हैं। वो बोले कि उसके बाद रोक दिए, ठीक है, लेकिन ये भी आपके विटनेस ने बोला है कि अब जो है हमने एक ऑल्टरनेटिव सीढ़ी बना लिया, ये भी आपके विटनेस ने बोला है। At the same time, he has also stated that you have an alternative arrangement to go to the stress.
Yes, but only after that hindrance has been caused because उनका जो पैरा 29 में भी वो जो बोले हैं कि हमको नहीं पता था कि there was an injunction.
आज के दिन में जिस स्टेयरकेस को यूज करने की बात आप करते हैं वो एग्जिस्ट ही नहीं करता है, करेक्ट?
हम अभी हुजूर के सामने स्टेयरकेस को प्लेस भी नहीं किया, but there is a passage.
पैसेज है तो क्या? पैसेज इज टू गो टू द स्टेयरकेस एंड गो टू द टेरेस. दैट इज द होल पर्पस ऑफ दिस राइट व्हिच हैज बीन कन्फर्ड इन द गिफ्ट डीड. बताइए और आपको क्या बोलना है?
इसमें हुजूर को ये कहना चाहूँगा कि shall I say something, submit something on section 11 of the transfer of property because last day they said something or after the argument of my senior I say something on section 11. Submit something on.
We don't bother about section 11. That is not a substantial question of law. I will not, Mr. Rahul Gupta, We are not concerned with section 11.
Section 11 I have just placed, but
It's
it
just a
is
passing reference.
only, yes, only. Now, one thing is very important. Now, with regard to the easement, as your Lordship put a query to them, what was actually transferred is 334 work feet. That is the give deed, the areas mentioned, and that does not include the
Let him
passage.
complete. Section 11 का आप मत सोचिए, उसके बारे में हम कुछ नहीं बोलने वाले.
Or sale, my sale deed by which I have the property.
The whole fact is the three elements, good conscience and the three elements. Right? Whether these three elements have been ignored by the court by deciding on this. Central point for you.
was not ignored, therefore the decree has been passed in
That's
our
it.
favor.
We'll see whether it has been properly considered. That is a substantial question of law for you.
Because the question of subsequent ceiling it was erected only after the blockage has been done. Prior to that, so no one shall be permitted to take advantage of his own wrong. If I will be prevented from going someone, it is a natural human course that he will find some other routes. So if subsequently he has erected that ceiling, it's not nothing wrong.
You have done two things. You have also demolished that ceiling. That does not exist anymore. You have converted that space into a room. That is also a fact.
No. यहाँ पे मुझे एक चीज हमको बताना था ये जो कल जो हम लोग नक्शा देख रहे थे और जिस जगह पे
ये जगह दीजिए.
हम लोग बता रहे थे वो जगह पे वो एक्चुअली में सीढ़ी है ही और सीढ़ी है जो इसके नक्शा में भी है.
एक और जजमेंट.
ये जो प्राइवेट लैंड है जो यहाँ पे है वो जो सीढ़ी है that still exists right now. It still exists at present also.
कौन से एविडेंस से बोल रहे हैं?
Yes sir.
वो आप लीडर कमिश्नर का एविडेंस से दिखाइए.
लीडर कमिश्नर का भी और इसमें भी जो पैसेज हुई क्योंकि जहाँ पे जिस जगह पे सीढ़ी समझा जा रहा था तो या हम जब कल बोल रहे थे आई वाज रॉन्ग. बरामदा में वहाँ सीढ़ी नहीं है.
बरामदा में सीढ़ी नहीं.
यस.
फाइंडिंग है कि बरामदा के सीढ़ी से आप जाते थे.
लोग यही इसमें ये गिफ्ट हम दिखा दे रहे हैं.
नहीं गिफ्ट इससे नहीं. वो सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है. There is no substantial question of law framed that this finding recorded by the learned court is incorrect.
Yes, your lordship put a query to me that you have dismantled it, and I am saying
what I say is that there is no staircase existing at that point in time. At that place. There is no staircase existing at that place.
Still, that staircase is existed, and ये आया भी है इनका एविडेंस में भी DW7 का 24 में DW7 का 24 में staircase के बारे में छत के बारे में everything स्पष्ट है और आज भी है और वो पुराना staircase है बहुत पुराना 1981 के उस समय से है अभी भी still exists. When I am placing argument before your my lord. Therefore, the question of demolition does not arise, and the subsequent erection of CD, just I have submitted that it is a common natural course, and no one should take advantage of his own wrong, because admittedly, in para 29, he has obstructed. So, once he has obstructed, 25 साल लंबा दौर है I have to go to my roof, I have to take some alternative arrangement. So subsequently I have taken alternative arrangement. So it doesn't mean that the right has been extinguished to me, because the right has been created in the year 1981 when the gift deed has been executed prior to the sale deed, and from that I was exercising that right, and in the year 2000 when the sale has taken place, then the new purchaser come and close the door. So the right was continuous. Only in the year 2000 that my right has been deprived. It was जो घर था वो जो प्लेंटिफ थी उसकी माँ का था वो एक एरिया दे दी अपनी बहू को और एक एरिया अपने बेटे को. So जो कॉमन अरेंजमेंट था ये स्पष्ट होता है कि it was earlier like a family arrangement. कि आप इधर से भी जा सकते हो आप ये कर सकते हो. Subsequently, in the 2000 when the other family members has entered into
you see the property, entire property originally belonged to
Tara Devi. Who is the mother of the plaintiff?
Mother of, just a moment. Who is the mother of the plaintiff,
Yes, ma'am.
right?
Yes.
She gifted in
1981 में prior to
1981. Then she transferred the property, remaining property to. She transferred only a portion of the property in schedule in B mark.
Yes, ma'am.
In mark B, she transferred
Yes, ma'am.
to whom? To a third party.
Krishna Devi.
To a third party.
Yes, ma'am. Third party. Earlier in 1981 वो जो कृष्णा देवी है वो उसकी बहू है. हर ओन जो तारा देवी जो गिफ्ट देती है उसके 2 महीना बाद जो करती है वो अपने बेटा की मतलब दूसरे बेटा की बहू है उनके
डॉटर इन लॉ.
यस.
उसके बाद क्या हुआ?
उसके बाद जो इन द ईयर 2000 दैट कृष्णा देवी हैज सोल्ड
अभी प्रॉपर्टी किसके पास है? डॉटर इन लॉ के पास है.
No, in 2000 that property is the appellant के पास चला गया 2000 में जब सोल्ड हो गया
2000 में सेल कर दिया
हाँ.
डॉटर इन लॉ ने.
हाँ 2000 में then the entire dispute has been dropped जब फैमिली से बाहर निकल के चला गया.
Sold it to
सुलोचना देवी the appellant.
and that is the B marked portion.
Yes.
ठीक? B block.
Yes.
This lady Tara Devi has expired.
Yes.
And right now you are in possession of entire A block.
Yes.
Okay.
इसमें एक जो पैसेज का जो बात हो रहा है फिर लॉसेस में अलाउ मी टू सबमिट कि कहाँ पे वो पैसेज था वो जो बी ब्लॉक है बी ब्लॉक के नीचे जो है बी ब्लॉक से नीचे का वो पैसेज है बी ब्लॉक के जस्ट पीछे वो पैसेज
पीछे मतलब?
ये बी ब्लॉक के नीचे yesterday हम आपको जो बोले थे हम उतना रेडी नहीं हुए बट ऑन द लास्ट टाइम डिटेल डिस्कशन एंड दोनों मैप से मिल जा रहा है कहाँ पे पैसेज है किसको लेके
ये तो पैसेज है ही.
हाँ वो जो ये
नहीं, इस पैसेज से सीढ़ी कहाँ पर है? आप हमको ये गिफ्ट डीड से दिखाइए. व्हाट इज द लोकेशन ऑफ द स्टेयरकेस?
यस मैम गिफ्ट डीड हम बोले हुजूर को कि आई कंसीडर हम हुजूर को बोले कि गिफ्ट डीड में स्टेयरकेस नहीं है.
स्टेयरकेस का लोकेशन है ही नहीं. स्टेयरकेस है ही नहीं.
यस बट दैट इज ट्रू बट देयर इज ओनली गिफ्ट डीड में पैसेज है.
Only passage.
Yes.
There is no staircase.
Yes, only this. That's true, Lord.
Yes.
If not, I would have Lord gone through Lord अगर थोड़ा देर पहले मैं जाता हूँ तो हम कहीं उनको सामने करते हैं.
And when passage is leading to vacant land, that is what we are.
That is a passage, Lord. Only one passage, Lord. We are praying, Lord. That Lord, the right Lord has been.
Passage is leading to vacant land.
That passage, Lord. That passage तो उनको vacant land उनको भी कोई problem नहीं, उनको भी कोई problem नहीं. That right.
That vacant land. अब उस vacant land में बन गया घर.
और passage है still. That passage still exists.
So that passage still exists. अब कौन सा passage है? अब तो ये block है.
नहीं ये पैसेज आज भी एग्जिस्ट करता है.
भाई ये passage तो है. But the point is that this is a dead end. This passage is a dead end now. ये passage से कहाँ जाइएगा? उनके घर के अंदर. इस पैसेज से आप कहाँ लैंड करिएगा? घर के अंदर. यही चाहते हैं आप उनके घर में घुसना?
उनका घर तो सेपरेट है.
नहीं, सेपरेट है मतलब ये जो ब्लॉक बी है, यू जस्ट सी ब्लॉक बी. ब्लॉक बी इज लाइक पैसेज है, ठीक है, उसके बाद ये तो पूरा डिपेंडेंट का पूरा रूम है।
उसके बाद स्टेयरकेस है इसमें जो
हाँ ठीक है,
स्टेयरकेस
ये तो अभी का स्टेयरकेस है ना, पहले तो था ही नहीं ये स्टेयरकेस।
यही स्टेयरकेस था पहले से।
ये कहाँ से बोलेंगे आप? From where will you say this? In your gift deed, it is a vacant land. Staircase कहाँ? हवा में?
स्टेयरकेस जो नक्शा में
भाई आपका सिंगल रूम घर है, राइट?
हम नहीं बोल रहे हैं, तो बोल रहे हैं DT.12.07 बोल रहे हैं।
आपका नक्शा नहीं देखें, गिफ्ट डीड ना देखें।
गिफ्ट डीड में
गिफ्ट डीड में ना तो स्टेयरकेस है as per the map and the passage is leading to an open space.
गिफ्ट डीड में जो नक्शा में नहीं है, जो बट गिफ्ट डीड में का रिसाइटल में है। इसमें इट्स अ लॉर्डशिप टू कंसीडर, बट आई हैव नथिंग टू से। आई एम ओनली सबमिटिंग बट इट्स अ लॉर्डशिप टू कंसीडर मतलब कि गिफ्ट डीड का नक्शा में, और जो मेरा सबमिशन ये है कि मतलब it is to the gift deed is to be did as a whole, सिर्फ नक्शा को नहीं, entire is to be seen and evidence act में एक जगह है when there is a difficulty कि which of the two then say for example if A says that I have a house at I do sold house at हावड़ा, लेकिन उसका हाउस जो है हावड़ा में नहीं होकर के कोलकाता में, तो मतलब अकॉर्डिंग व्यू ऑफ सेक्शन एविडेंस एक्ट में इट इज टू बी ड्यूड दैट ही इज सेइंग अबाउट द हाउस व्हिच इज सिचुएटेड एट द कैलकाटा, तो देयर इज नो अनदर हाउस। इनका DW7 स्पेसिफिकली 24 में बोलते हैं कि हाँ वहाँ पैसेज है, वहाँ नल नहीं था, लेकिन एक सीढ़ी है, पुरानी सीढ़ी है, वो सीढ़ी छत पे जाती है, छत पे एक वाल है एंड एवरीथिंग। पैरा 24 में भी सीन ब्लॉट एक बार के लिए। सो ब्लॉट if ब्लॉट समथिंग हैज बीन omitted ब्लॉट in ब्लॉट नक्शा, but ब्लॉट that is supplied by the evidence ब्लॉट and the ब्लॉट recital of the deed ब्लॉट, that is to be seen Lord, because that still exists when I am argumenting before your Lord, and Lord, it shows and it depicts in the Lord the naksha or the map made by Lord the commissioner Lord, which is के सामने उसमें भी नजर आ रहा है सीन। So Lord, this is my whole argument. Now your Lordship is to consider and Lord, I'm not saying on section 48 specifically, but I'm saying in general parlance जो earlier जो deed होता है उसी को देखा जाता है, because earlier if something has been sold or created in favor of someone then जो पहले आता है उसको precedence देना, subsequent को नहीं। This is the general law, not specifically stating 48. It's my whole argument. I'm sorry for
No, it's okay. Well, it's a part of your job. You don't need to be sorry about it. It's a part of your job and you have to argue your case.
It's very easy.
कोर्ट के बोलने से थोड़ी होता है, आप ना ही अपीलेंट के बोलने से आप पीछे हट जाइएगा।
हम लोगों को अपना फुल जितना भी हमारे पास है क्लाइंट के,
देखिए आपका जितना भी एंशियस, कोई भी पार्टी जब बहुत एंशियसली आर्ग्यू करता है तो हम उसको बहुत ध्यान से सुनते हैं, क्योंकि लगता है कि कहीं तो कुछ रीज़न है एंग्जाइटी का, कुछ तो ऐसी बात है कि हो सकता है सुनने से कुछ नई चीज़ें पता लग जाए। तो ऐसी बात नहीं है। एंड योर आर्ग्यूमेंट इज ऑलवेज वेलकम, देयर इज नो प्रॉब्लम अबाउट इट, बट वी हैव टू गो एज पर इट। And you have always been very passionate in arguing your case. There is no doubt on that. Okay? हाँ बताइए।
Only to come. Now, para 14 of the appellate court's judgment you may kindly receive. What the appellate court says with regard to the deed of gift and to the initial sale. Now, we have already seen the deed of gift.
Yes.
There is a right given to common passage. That right is there. I cannot shut my eyes with that. Now, when that right was given to the plaintiff here, and subsequently the same Tara Devi, who was the donor of the property, she transfers the property after gift deed to my vendor. To my vendor, she transfers it in the year 1981 itself. And creating an absolute interest in favor of my vendor, that deed is not inside. That deed was, if it was affecting them, it was required to have been challenged. That she was.
No, he says that it is irrelevant. He need not challenge it because the transfer is subject to whatever right was created in favor.
It was hurting them, and Tara Devi would not have transferred an absolute interest. She would not have. Then they were affected by that sale deed, whereby the complete transfer was made and they did not challenge. So the appellate court says that my sale deed does not mention anything about the earlier deed. So if it was the person who was being affected, he was required to. And as this honorable court has already noted it, that if it is the deed of gift is compared with the report, then it would be seen that there was absolutely complete change in the setup, entire setup. Now, in the deed of gift, the veranda was there, now the plaintiff has already constructed room.
You see, this property, you come to the, just for a clarification from both of you on this, when we see the pleader commissioner's report,
Yes.
this property, room 1, room 2, room 3,
Yes.
in A,
Yes.
this is in occupation of the plaintiff.
Yes.
Now, there is a finding of the learned first appellate court that Tara Devi also granted right to use staircase situated in courtyard to go to the roof through the gift deed. Now, access, this is the courtyard, room 2.
Yes.
Room 2 is the
Yes.
courtyard.
Yes. Yes.
Now, access to room 2 is now available to him through room 3. Direct
Because
access is
the
available.
staircase, if they want to, yes. If they
This
want,
access, earlier this room 2 and room 3 was vacant land, room 2 was the courtyard. Now, by virtue of this particular possession, that is why I wanted to know as to relationship, because this room 3 has not been sold to anybody. Room 3 in A is in possession,
room 1, 2 and 3, entire portion.
belongs to him.
Yes.
He must have succeeded from Tara Devi.
Yes.
He must have succeeded from it, belongs to him. Yes. Now, access to staircase in the courtyard is available through room 3 also.
I'll clarify one thing. There is no courtyard now in room
It does not
because
exist.
they themselves have changed the entire and they have themselves constructed room which was earlier a courtyard. So there is no courtyard as of now.
No, one of the argument is that his right on the date of the filing of the suit has to be seen. So then also,
They themselves have changed it.
they themselves are changes and they have access to room 2, the courtyard, through room 3.
No, they have direct access from the front portion itself, from the road.
Yes,
itself.
from the road also they have
Yes,
direct
yes,
access.
yes.
And from this side also they have
Yes,
direct
yes.
access to all of
And
it.
the pleader commissioner's report would show that in all the 3 rooms there is a door
You see,
and the window.
from this lane, Harshuk Sa lane,
Yeah.
these are the shops. So they may not have access through the
No,
shops.
these are his rooms.
No, these are his shops perhaps. Yeah, dukaan
They
hai na?
have changed.
They have changed.
They have changed, not me.
But otherwise
So
also from this gully they
Yes,
have an
yes.
access, direct access to it.
They have. And
To
if
the
they-
courtyard they have a direct access from both the lanes.
Yes, if they want to go to it, they have already constructed a
Staircase.
staircase.
Okay.
So what they want now, that this staircase which is shown in the map of the pleader commissioner, it was not existing even in 1981.
It is not there.
There would not be any staircase in a vacant land. Cannot be. Because there's no mention of the staircase, and staircase to what?
Achha, take a look.
And my rooms are just all these constructions have been made, and courtyard I have made. Now in the report, this courtyard was earlier not there, so it is my
You have undertaken your construction.
it is my construction, and I have made that portion. It was not there in 1981 and defendant's room and defendant's kitchen is there. So that passage would not lead to anywhere else except my own house.
Okay. For the learned counsel appearing on behalf of the parties. This appeal has been admitted for final hearing. Wide. Substantial question of law. By framing three substantial questions of law as contained in order dated 25/2/2019. However, the third substantial question of law was deleted with the consent of the parties by order dated 29th of April 2025. And consequently, only two questions of law survive for consideration, which are as follows. कुछ और बनाए तो नहीं है? ठीक. The title suit number 127 of 2000 was filed by the sole plaintiff dated namely Ganesh Thakur on 11/12/2000 against the sole defendant namely Srimati Sulochana Devi. Seeking a decree that the defendant is not entitled to obstruct the common passage used and utilized by the plaintiff, and also with a prayer for injunction restraining the defendant from obstructing the common passage of the plaintiff, and further a direction upon the defendant to remove the materials wrongfully heaped up near the common passage. The entire case of the plaintiff was based on a gift deed having executed by his mother in plot number 507 capital A, having an area of 334 square feet and a house thereon with one room, one veranda, and right to use and utilize common place, and a right to enter into the courtyard and right to go up and down through the staircase to the roof, which is said to be well marked in the sketch map by virtue of the gift deed dated 6/7/1981. The adjoining land, which was also owned by the mother of the plaintiff, named Tara Devi, was sold by her on 8/9/1981 to Krishna Devi, who as per the respondent was the daughter-in-law of Tara Devi. However, said Krishna Devi sold the land to the defendant on 17/11/2000. And since then, 17/11/2000, knowing fully well ऐसे लिखिएगा on 17/11/2000 which included the passage area. The case of the plaintiff was that they enjoyed the passage and access they enjoyed the passage for 19 years and the defendant had no right to restrict. And by words on 18/11/2000, the defendant obstructed the plaintiff from using the common passage and entering into the courtyard and using the staircase to reach the roof of the house of the plaintiff. Consequently, the suit was filed. The defendant filed a written statement denying the allegation and the claim of the plaintiff and also alleged that Tara Devi was an illiterate lady and she had no knowledge of the language in which the deed was written. And also asserted that the plaintiff had not exercised/used the passage and the staircase even for a single day. It was also asserted that Tara Devi had transferred 925 square feet together with house constructed had 925 square feet by way of sale deed to Krishna Devi on 8/9/1981 by registered deed, and after purchasing the same, Krishna Devi came in possession. It was also asserted that there is no sign of use of passage towards the property of Krishna Devi. And the defendant had purchased the property from Krishna Devi and was in possession over the same, together with the building standing thereon. it was also asserted that there was no need for the plaintiff to use the passage as because the entire 334 square feet of the land of the plaintiff falls in the main road. That is Hari Kishun Shah Road. The perusal of the plaint and the written statement reveals that the suit was essentially seeking right to easement and the plaintiff claimed access to the staircase through the passage. And the entire case of the plaintiff is essentially based on the right conferred to the plaintiff through the gift deed. Both the parties led oral and documentary evidences before the court, and the trial court decreed the suit, and the learned first appellate court has dismissed the appeal filed by the defendant. Consequently, the defendant is the appellant before this court. The counsels have placed the findings recorded by the learned first appellate court, and also the gift deed along with its map and the pleader commissioner's report along with the map. The gift deed was marked exhibit. Gift deed was marked exhibit 1. Exhibit 1. The map in the gift deed was also exhibited.
Which year?
Forms part of the
Map is a part of the exhibit.
Exhibit 1 along with the map. Yes. And the pleader commissioner's report. You see, map is gift deed is exhibit 1 and map is exhibit 2. You will find it at internal page 5 of the appellate court statement. I remember map has been exhibited separately. The sale deeds which has been referred to above have also been exhibited. The map in the sale deed has also been exhibited. The pleader commissioner's report has been exhibited as exhibit D, exhibit E, and the pleader commissioner's report also contains a map upon local inspection. the learned trial court. The learned first appellate court had framed the following points for consideration. Para 8 ka 1, 2, 3. The learned first appellate court, after considering the materials on record, has recorded in paragraph 13 that the principles of justice, equity and good conscience would be applicable to the law relating to easement in Santhal Pargana. During the course of argument, it is not in dispute that Easement Act as such is not applicable in the present case. वो judgment लाए हैं क्या?
35 Patna.
हाँ.
Where
In the judgment passed by Honorable Patna High Court, reported in a 1935 SCC Online Patna 21, equivalent AIR 1935 Patna 188. थोड़ा मार्क करके देंगे ना
हम
प्लीज.
देख
इट हैज बीन हेल्ड एज
शेयर कॉपी हम लिए थे, हम AIR में मार्क किया हुआ है इसमें।
अच्छा अच्छा.
And even otherwise in SPT Act regulation, I do not find easement act.
नहीं नहीं
because
वो तो
it
इसमें
contains a
इसमें
list
डाउट
of
नहीं है. आई एम श्योर ऑफ दिस, बट स्टिल यू नो व्हेनेवर वी आर प्रोनाउंसिंग ऑन ए जजमेंट, तो ये कुछ गाइडेंस होता है सिविल कोर्ट्स के लिए भी. दे शुड नो दैट इट इज नॉट एप्लीकेबल. किसी दिन ईजमेंट एक्ट हम एक आध केस में देख रहे थे, ईजमेंट एक्ट लगाकर जजमेंट कर दी.
para 3.
पैरा 3 which is quoted
Para
as
3
under.
of this judgment, it says, and this certainly included the right to appropriate damages and so and so. We have therefore, by reason of provisions of Section 2 of Limitation Act and in the circumstances of the case, there being no license and there being no relationship of landlord and tenant to deal with an easement. The Easement Act does not apply to this province, hence, but the law relating to easement, which is the law of justice, equity and good conscience in this respect,
ये
excepting
जो लास्ट
in-
क्वेश्चन है ना, इसको पुट कर दे. द ईजमेंट एक्ट डज नॉट अप्लाई. The first appellate court has, while upholding the judgment passed by the learned trial court, has also held that the plaintiff was granted the right of usage of common passage. The donor Tara Devi, and also right to use the staircase situated in courtyard to go to the roof through the gift deed dated 6/7/1981, and the aforesaid registered gift deed has not been revoked prior to execution of the said deed dated 8/9/1981. The court ultimately held that the plaintiff was granted right of easement to use the common passage and use of staircase situated in the courtyard to go on the roof by the deed. and held that the right of easement has not come to an end due to execution of the sale deed dated 8/9/1981 by Tara Devi in favor of Krishna Devi. The learned counsel for the appellant, while advancing his arguments, has submitted that the learned courts, while considering the facts and circumstances of the case, have failed to apply the principles of justice, equity, and good conscience. He has submitted that the pleader commissioner's report revealed that the entire block A of the property, which includes the gifted property as well as a portion of the property which originally belonged to Tara Devi, is in possession of the plaintiff, and the entire property is rectangular in nature and has access to main road and also side lane at two sites. One on the longitudinal side and other on the one on the length side and other on the breadth side. The learned counsel has also submitted that the pleader commissioner's report also revealed that there is a staircase over the property in possession of the plaintiff, and he has access to his terrace. The learned counsel has submitted that the entire block of area in possession of the plaintiff has been divided into 3 rooms. The courtyard, which is veranda likha hai, courtyard likha hai.
Veranda, which was
The veranda which was shown in the gift deed has been shown as a room.
now has been converted by them into a room.
Now it has been converted by the plaintiff into a room.
And all the 3 rooms have separate, absolute direct doors connecting to it.
It is itna nahi.
नहीं, ठीक है, ठीक है.
The learned counsel has submitted that the gift deed also reveals that at the time of gift, there was only one room and veranda adjoining to it, and the location of the veranda is not mentioned in the map of the gift deed. The location of the staircase is not mentioned in the gift deed. However, the passage is away from the veranda by 18 feet. by 18 feet
Yes, and common passage,
is beyond 18 feet
yes. And
from the veranda.
common passage, only land is,
Okay.
is being,
And the common passage
leads to the land.
leads to vacant land, and the adjoining to common passage is also a vacant land
Yes.
of Tara Devi, the mother of the plaintiff. The Learned Counsel has also submitted that now the 18 feet wide land adjoining to the room, veranda, and also vacant space in front of veranda has been sold out to the defendant by the vendor of Tara Devi. Vendor of Tara Devi.
नहीं, vendor of
By the vendee of Tara Devi.
हाँ,
By the vendee of Tara Devi. And the map as filed by the pleader commissioner also reveals that the entire area has been converted into consists of constructed house of the defendant.
yes.
The Learned Counsel submits that the principles of justice, equity, and good conscience, when applied to the facts of this case, the suit could not have been decreed as the plaintiff had adequate access to the veranda and also to the adjoining land which is in his possession and which was earlier owned by Tara Devi, and the plaintiff being the son of Tara Devi, he is now in possession of the land adjoining to the veranda, and the entire rectangular portion of the land has enough access to the main road as well as the private lane. यही है आपका?
हाँ, extreme ये road side का portion का land, not the land of Tara, जो
हाँ
जो gift deed में है,
हाँ।
चूँकि दो जगह land लिखा हुआ, तीन जगह in fact लिखा हुआ इसमें होगा,
ठीक
which is marked as as B in the gift deed.
land of the defendant is marked B in the map.
नहीं, जो उनको ट्रांसफर हुआ उसका गिफ्ट डीड हम दिखा, गिफ्ट एक थोड़ा सा उसमें
हाँ
fact
आप बताएं.
ये जो बी लिखा हुआ है वो एक रूम, veranda and the portion which is marked B on the corner, all those were transferred.
हाँ it is in his
तो
possession.
नहीं, वो लिखा गया कि vacant land, तो it cannot.
अच्छा this
मतलब
was
पूरा
also
भी-
transferred to him. This B was also transferred to him.
हाँ हाँ, ये पूरा portion, straight portion has been transferred. Therefore now what they have done, now if it is compared with the pleader commissioner's report, here in the land they have constructed the staircase of their own. They have already constructed.
The Learned Counsel submits that the room, land, veranda and vacant land in front of veranda
Yes.
is the property of the plaintiff.
Yes.
The Learned Counsel, appearing on behalf of the respondents by opposing the prayer, has submitted that it has sufficiently come on record through oral evidence that the defendant had blocked the access immediately prior to filing of the suit That is on 17/11. क्या डेट बताया आप?
क्या चीज का भी?
Obstruction का डेट.
हाँ.
That is with effect from 18/11/2000. The Learned Counsel submits that for long duration, the passage was being used by the plaintiff, and the passage was utilized to access the staircase. The Learned Counsel has also submitted that on immediately before the date of filing the suit, the passage was blocked, and therefore such obstruction could not have been created by the defendant. He has also referred to the gift deed and has submitted that the description of property in the gift deed clearly reveals that the plaintiff was entitled to use the passage to use the staircase in order to go to the terrace. He has submitted that such right having been conferred through a registered gift deed does not extinguish by virtue of transfer of the passage by virtue of transfer of the passage to the defendant. The Learned Counsel has referred to Section 48 of the Transfer of Property Act and has submitted that the right of the defendant to use the passage to the staircase still survives, and that does not extinguish. और कुछ बोलना है आपको?
29 of DT.12.02.2026.
वो तो हो ही गया. The Learned Counsel has submitted that. ये तो फाइंडिंग में ही है, इसमें तो कोई डाउट ही नहीं है. That now there is no doubt that the access was blocked only on 18/11/2000, as is apparent from the cross-examination of the witness PW7. The Learned Counsel for the appellant in response has submitted that the suit was seeking right of easement, and the gift deed itself reveals that the property which was transferred was specifically 334 square feet, covering a room, the veranda in front of the room, and the land in front of the veranda. He submits that the gift deed has transferred the property what is specifically referred to, and no more. That's it.
Yes. And I'm relying on 2-3 judgments from the Supreme Court where it has been said that the right to access through prescription would be only to if it is lost, if it is there is an alternative.
The Learned Counsel for the appellant has also relied upon the judgment passed by the Honorable Supreme Court reported in
AIR 2005 Supreme Court
AIR 2005 Supreme Court
236.
236 para number,
Para number is 9 and 10.
para 9 and 10. To submit that the right of easement can be lost with passage of time, and he submits that since the plaintiff had full access to the staircase which is said to have, which has been found to be located in the veranda as per the learned first appellate court's judgment. Therefore, and has also constructed a staircase and converted the veranda into a room. Therefore, the alleged right of easement does not survive anymore.
Yes, exactly.
खोज रहे थे हमको बहुत पुराना जजमेंट मिला मद्रास हाई
एक और ये रिसेंट 2024 का है, इसमें भी वही reiterating what was there in 2005. The easementary right by necessity could be acquired only in accordance with section 13 of the Act, which provide that such easementary right would arise in
नहीं आप easement act में मत जाइए.
ठीक है.
The learned counsel submits that a substantial question of law be answered in favor of the appellant and the appeal be allowed.
One more submission was missing, that they have not challenged my deed by which the property was transferred to me. Absolutely.
The learned counsel has also submitted that the defendant has not, the plaintiff has not challenged the deed, the registered deed of the defendant by which the absolute right with respect to the property, including the passage,
Yes.
has been transferred in favor of the defendant.
Yes.
That's it.
But neither the original transfer nor the subject. That is all.
The deed in favor of the vendor of the defendant has also never been challenged. That's it.
Yes. That is all.
अब लिखाएंगे नहीं. I'm just pronouncing it
हाँ.
क्योंकि submissions आपका लिखा दिए हैं. हम जाएंगे चेंबर में हम
नहीं
लिखाएंगे.
नहीं जैसा
ठीक है. The substantial question of law is answered in favor of the appellant. The appeal is allowed. You will get the judgment. In 2-3 days time you will get the judgment. Gaurav, I have said 2-3 days time. It should be 2-3 days time. आपको कितना टाइम लगेगा? एक हफ्ता में अपलोड कर दें? एक हफ्ता में? 1 week?
She had prepared a short synopsis.
बहुत लिखाना पड़ेगा
नहीं,
इसीलिए.
ये सिर्फ relevant dates और सब लिखा हुआ है.
ठीक है, दे
I'm
दीजिए.
just submitting it, and the two judgment on which I have.
वो दोनों जजमेंट्स भी दे दिए.
अब दे.
In case submission के case में वो it was not incumbent upon the this plaintiff to challenge the same.
अच्छा एक चीज सौरभ 1 sentence.
Section 20.
किस
Section 48.
अच्छा, अच्छा, 48 में.
It was not incumbent to challenge, but the first deed is to be
Okay.
always.
The learned counsel for the respondent has also submitted that there was no need to challenge the deed executed in favor of the defendant in view of section 48 of the Transfer of Property Act, as no one can transfer better title than what he has, and नहीं ये मत लिखिए, लास्ट ये मत लिखिए. As the previous gift deed would prevail over the sale deed, and the right of easement of the plaintiff would remain intact, irrespective of the sale deeds executed in favor of the defendant. ठीक है?
लॉर्डशिप का इसमें अगर लॉर्डशिप हमको परमिशन दे तो
अब हो गया ना. आपको इतना देर सुन लिया. दिस इज नॉट आपको परमिशन.
जजमेंट के लिए बोला.
नहीं, आपको जजमेंट नहीं. हम तो जाते ही लिखाएंगे, या तो 4:30 बजे लिखाएंगे या 1:30 बजे लिखाएंगे, क्योंकि बाद में हम भूल जाएंगे ना, इसीलिए हम लिखा ही देंगे उसको. करेक्शन करने में जितना टाइम लगे वो अलग बात.
From supplementary list under heading for orders with effect, item 2, FA 11524 of 2024, filing number.
Not possible once. Darling in confirmation.
इसमें क्या है? डिफेक्ट में है ना?
जी डिफेक्टिव है।
क्यों नहीं आपने आईए फाइल किया है ना आपने? तो ये तो आईए है आप, इसमें क्या दिक्कत है आपको?
Just a short answer.
You are seeking amendment, so I will allow it. Filing number filing FA number 11524 of 24. IA number 13125 of 24 has been filed by the appellant, seeking to allow / grant leave to the appellant to amend the appeal value of the memo of appeal. And it has been also asserted that the appeal value has been wrongly mentioned as 25 lakhs instead of 1 crore 10 lakhs, instead of 1 comma 00 comma 00, sorry, 1 comma 10 comma 00 comma 100. The prayer is allowed. The counsel for the appellant is permitted to amend the appeal value. अभी आ जाएंगे करवा देंगे within a period of 1 week entry. He is permitted to do the needful during the course of the DSP. ये वाला एक थोड़ा सा लेके रखेंगे, ठीक है? प्रेमजी, the office is exiting. The deficit court fees we also filed. The deficit court fees we filed within a period of 1 week thereafter. Check.
One week.
हाँ, 1 week.
Item 3, first appeal 1177 of 6 of 2024 filing.
What? कब मरे हैं? When did he die? Date of death?
4/8/24.
After the judgment. Filing number FA 11776 of 24. IA number 12148 of 24 has been filed, seeking the legal with a prayer to allow the legal heir of the body number 4 to pursue the present appeal.
Already parties have been made.
He has already been made party as appellant number ये तो काट दिए हैं, काटा हुआ है। सूरज साव नाम काटा हुआ है। He was earlier made appellant number 4, but his name has been deleted by the appellant, by the counsel for the appellant. The learned counsel submits that he may be permitted to make necessary correction in the cause title so as to retain his name. The learned counsel has also submitted that by mistake a prayer for substitution has been made. Although awardee number 4 expired after the passing of the impugned judgment, not after the passing of the impugned judgment, 29 days, after the passing of the impugned judgment. Considering the submissions, the awardee, the deponent of IA number 12148 of 24, namely Suraj Sao, son of late Prakash Sao, is permitted to pursue the present appeal. The learned counsel for the appellant is directed to make necessary corrections in the cause title. This order has been passed only for the purposes of the present first appeal, and the concerned court would make the necessary verifications at the time of disbursement of the awarded amount. अब बताइए क्या है इसमें? कितना? 118 days. Where is the counsel for the state? बताइए कहाँ क्या लिखे हैं? Lack of money and knowledge. IA number 12149 of 24 has been filed seeking condonation of delay of 118 days, as pointed out by the office. The learned counsel has submitted that the delay is beyond the control of the appellant, and because of paucity of money and lack of knowledge, and the land of the appellant has already been taken away. Being satisfied with the cause shown, the delay in filing the appeal is hereby condoned. और बताइए, बाकी सब केसेस कहाँ हैं? नहीं ऐसा नहीं, सबका फाइलिंग नंबर के साथ बताइए। कोई भी एडमिट हुआ है? Admit call for the records from the concerned court. Let this order be communicated through fax. Let this order be communicated to the Office of Learned Advocate General to ensure appearance of the counsel for the state. और बताइए, बाकी सब आज कौन-कौन सा केस है लिस्ट में? बाकी सब में यही कहानी है। एक सिर्फ ओनली कॉन्वोल्यूशन ऑफ डिले दिखाई सर। आप स्टेट हैं, आपका अपीयरेंस रिकॉर्ड कर दें। डिले है 118 डेज का लैंड एक्विजिशन मैटर में, कंडोन कर देते हैं। डिले में क्या है, उसमें इनका अपीयरेंस रिकॉर्ड कर दीजिए स्टेट। आप एक सेकंड बताइए कौन सा सीरियल नंबर 4 हो गया?
नहीं नहीं
ये
अभी
3 था
four
जैसे
में।
अभी जो था।
अच्छा ये 3 था।
जी,
इसमें दोनों आई अलग हो गए।
ये four में
सीरियल नंबर 3 तो नहीं है, 2
3 अभी हुआ।
2 तो हो गया, अभी 3 हुआ है।
जी
ये दोनों आईएएस में से अलाउ कर दिए, ठीक है। और इसमें
इसमें फोर में सीरियल नंबर 4 में
हाँ।
आगे नंबर 1
ये तो लिमिटेशन कितना है, 118 डेज,
नहीं 83 डेज
83 डेज। डिले कंडोन कर दें, इसमें 83 डेज का डिले है, इसको कंडोन कर दीजिए। और बताइए लीव टू अपील क्या है, व्हाट इज दिस?
एवाडी नंबर 3 डेट कर रहे हैं
चलाइए रिकॉर्ड।
और पार्टी 4 and 5
अवॉर्डी नंबर
3 and 4 भानु करमाली डाइड ऑन 13/7/2024।
आप जो उसमें अमेंड करेंगे ना, आपने पूरा का पूरा वो नंबर चेंज कर दिया है, तो उसके एंड में करेंगे। और नंबरिंग सबसे लास्ट में जो आप पिलान करेंगे ना, उसको लास्ट में अमेंड करेंगे, है ना। उसी में मत फिर से रंग दीजिएगा, वो सीक्वेंस में जो अपीलांट है 1 2 3 4 करके सीक्वेंस भी चेंज कर दिए आप, अपीलांट्स के लास्ट में उसको डालेंगे, ठीक है। बोथ लीगल ईयर्स ऑफ अवॉर्डी नंबर 3, अच्छा 3 चरकी देवी एंड दिस, ठीक है। यही तो डेथ कब हुआ?
13/7/24
आफ्टर द जजमेंट। लिखिए एफए फाइलिंग नंबर 11789 of 24। The counsel for the appellant has submitted that awardee number 3 had expired after the filing of the judgment, after the passing of the impugned judgment, and therefore a petition has been filed so as to enable their legal heirs to pursue this appeal. They have already made party in the present proceedings as appellant number 3 and 4. Counsel for the respondent has no objection so far as the prayer through IA, so far as the aforesaid prayer is concerned. Accordingly, IA number 12154 of 24 is allowed, and the legal heirs of award number 3 are permitted to pursue the present appeal. लेकिन वो राइडर रहेगा, है ना, इट इज ऑल सब्जेक्ट टू वेरिफिकेशन है। और आगे 1215 51,
12154
अच्छा ये 54 नॉट प्रेस्ड है।
नॉट
और जो आपका लीव टू अपील आप फाइल किए हैं,
वही अलाउ
नहीं उसका सेम टू सेम दूसरा है। ये अलाउ विनीत जी, देयर इज सम एरर। अलाउ करना है आईए नंबर 17408 और 25, ठीक है। और ये 12154 of 25 is dismissed as not pressed. डिले कॉन्डोनेशन बताइए कहाँ है, आइए नंबर
ग्रीन वाला
56
ग्रीन वाला, आइए नंबर 12156 कंडोन कर दीजिए, ठीक है। नेक्स्ट बताइए, और बाकी सब क्या है?
कॉमन जजमेंट है, तीनों को टैग कर दिया।
आइटम
3 4 5,
जी
ओके। और बाकी सब एफए नंबर कौन सा है?
अब इसमें आज के
6 वगैरह, इट इज अ डिफरेंट जजमेंट।
6 to 19.
6 to 19 are different judgment, okay. The 3 4 and 5 are tagged since the records have already been called for. Common order कर दीजिए इसको. They are directed to be tagged together. Special messenger cost जमा कराइए. The special messenger cost calling for the records be deposited by the appellant within a period of 1 week. सब admit कर दीजिए सारे. Remaining cases कब आ रहा है इसका? Remaining cases कब आ रहे हैं? How many cases आते हैं? आप हमको लिस्ट दे दीजिए. फाइलिंग नंबर दे दीजिए.
फाइल में भी लिमिटेशन का
फाइल में भी लिमिटेशन कितना है? 5 में भी 83 डेज है. 136. वकालतनामा के पीछे ना एग्जैक्ट फिगर रहता है ना, उसको चेक कर लेंगे. Post for final disposal on 24th March. आप है ना स्टेट? ठीक है. 24 मार्च को रिकॉर्ड आ जाएगा तब तक. Let this order be communicated through fax. 6 नंबर से बताइए.
Item 6.
हाँ बताइए.
What is the second instance correction? There is a defect in award. There is no difference in award and liability. That's number one. Number one is Deputy Commissioner to be Deputy Commissioner Palam instead of that in all the awards it has come to Commissioner Gadwa. Also there is defect of both fees.
सब में कोर्ट फीस कम है. इसमें तो कुछ भी नहीं है. They have not pointed out any such error.
In 6 and 7, not pointed out because that is of Gadwa. From 8 to 19, in all the cases, it is required to be sent for correction.
तो पहले तो ये जजमेंट तो अलग अलग है ना, कॉमन जजमेंट है.
अलग अलग है.
तो पहले इसका करें ना, इसका कोर्ट फीस क्यों नहीं जमा की? FA फाइलिंग नंबर 1598 of 2025.
Time it is. In total there are 21 cases, 14 is today, और पहले भी 7 हो चुका है.
542 डेज का डिले. आपने वकालतनामा फाइल कर दिया. आपको कोई ऑब्जेक्शन है डिले में?
6 केस तो हम भी किया पहले. उसमें बाकी जो दूसरा वाला मैटर उसमें
इसमें आप
पलाम का
सीरियल नंबर बताइए ना. सीरियल नंबर 6 टेक अप.
6 7 गढ़वा का उसमें ऑलरेडी अपील फाइल कर चुका.
अच्छा, यू हैव आल्सो फाइल्ड अपील. अपील का नंबर बताइए.
262/23.
FA
यस.
एडमिट हो गया.
नहीं अभी उसमें लिमिटेशन पे होगा, उतना मार्च में लगना है.
वो भी टाइम बाद है.
उसमें ज़्यादा नहीं है.
तो इसमें डिले कंडोन कर देते.
ये दोनों में 6 6 7.
फाइलिंग नंबर FA 1598 of 25. लेकिन आप तो अपना कोर्ट फीस नहीं जमा किया.
30 पहले टाइम मिल जाएगा.
Just a moment. Time till 25th February is granted to the appellant to remove the surviving defects pending. If the defects are removed within time, post this case on 10th of March. ये वाला ऑर्डर सेम होगा 6 and 7 बोथ. करेक्ट. और बाकी सब केस में उसमें भी कोर्ट फीस नहीं दिए. उसमें भी कोर्ट फीस नहीं किए. नहीं दिए. ये सीरियल नंबर 1 दिखाइए. इसमें आइए क्या चीज के लिए फाइल की लिमिटेशन
I is of limited.
देखिए फाइलिंग एफ ए नंबर 1600 of 2025 with other analogous cases. The learned counsel for the appellant submits that similar defects have been pointed out in all these cases. He submits that the award is required to be sent to the court concerned for correction. Office is directed to send the award to the court concerned for correction in all these cases, pointing out the defect which is required to be corrected. All these cases arise out of same judgment.
Same nature. Getting of the same, everything is same.
So far as the other defects are concerned, the counsel for the appellant is granted time till 25th of February to remove the same, failing which this appeal shall stand dismissed without reference to bench. Post on 11th March. किसका? आप दे दीजिए ना कॉपी. The learned counsel for the appellant is directed to serve copy of the memo of appeal and also the interlocutory application to the counsel appearing on behalf of the respondents by the appellant.
Not any other cases.
These are सब में applicant.
एक दो में वकालतनामा टूटा हुआ सब गढ़वा दो में
सिर्फ इसी में आप सब खुद से दे दीजिए ना.
नहीं नहीं ऐसे ही
ऐसे ही दे दीजिए. इसमें ऑर्डर का क्या काम है? आप ले लीजिए. और बताइए. ओके.
नहीं कुछ और ही दे दीजिए 19 तक कर ना
20 नंबर बताइए.
आइटम 20 FR 6902 of 2025 filing number.
क्या चीज के लिए फाइल की है?
But in this case, I will fight for removing the defect. Defect number 2, madam. So the defect number 2, for the payment of deficit court fees of 49,500.
Yes.
Madam, in this case, kindly appreciate another suit filed by the plaintiff, paying therein for certain relief. Number of time, that to refer the judgment. Start of page 23.
जजमेंट नहीं है. रिलीफ बताइए क्या है?
Relief, इसमें relief है. Page 34 of the judgment. In this case, madam, the
अरे भाई आपका डिग्री कहाँ है?
डिग्री हम लगाए हैं.
आप डिग्री में बताइए ना क्या रिलीफ है.
Page 61.
60.
For a decree declaring the title of the plaintiff over the property described in Schedule 1 below and permission
It
of
is a title suit.
title suit. But it is a simple title suit. I am in possession over the land. I am paying for the confirmation of possession.
So
I am not paying for the consequential.
you are seeking declaration of title.
The declaration of title.
Yes.
Simply cedar.
Declaration of title does not carry ad valorem court
My
fees.
lord, 6, my lord, the
Declaration of title does not carry ad valorem court fees.
my lord, according to the court has court fees of 1870, my lord. Wherein, my lord, Article 17(3), Schedule 2,
Article
एक जजमेंट तो किए थे, कहाँ है? एक ऑर्डर हम भी किए हैं इसमें। किसके केस में किए हैं? मिस्टर बीबी कुमार, उनको पता है, देखिए आइए। बीबी कुमार आपके फेवर में किए हैं भाई, हर चीज आपके अगेंस्ट में नहीं करते। वो लेके आइए, उनके पास वो है क्या हमारे पास? उनको दे दीजिए, आ जाइए सवाल।
From the release and rating for orders with effect item 3, second appeal 5106 of 2025.
अभी डिफेक्ट खत्म नहीं हुआ, क्या हुआ इसमें?
1360
प्रीएम्प्टिव ऑर्डर कर देते हैं। चलिए, काउंसिल फॉर द अपीलेंट praise for and is granted time till 25th February to remove the surviving defects. If the defects are removed within time, post on 11th March. Next, and appropriate.
Item 4. 517.
Same order? Same order. Then next.
Item 5.
कितना कोट फीस आपको? 6,180 रुपये।
प्रेमरी कर दिया।
Time till 18th March. Primary to remove the surviving defects. If the defects are removed within time, post this case on 25th of March. चलिए, कौन है ना 10:30 बजे केस? कॉल करिए उसको। हाँ, कॉल करिए।
Item 6, second appeal 6826 of 2025. Defective.
We are responding to mail and we've just received the Wakala count.
Counsel for the appellant is absent. At the request of the counsel for the respondent, the matter is adjourned and is directed to be posted on 11th of March.
Under heading for final disclosure, sheet states at 10:30, item 2, second appeal 249 of 2019.
Just received the information that respondent number 3 has died.
When? When?
In the month of March 2025. We are seeking 1 week time to file the supplementary petition.
This appeal has abated against respondent number 1 and 2 earlier. Correct? They have been substituted.
They have been substituted by order dated 16/12/2025.
16/12?
2024.
21.
24. 16/12/2024. We filed the IAA number 10249/2024, seeking substitution of respondent number 1 and 2.
Respondent number 3 has expired when?
In the month of March 2025.
Abate तो कर दिया ना?
We filed.
March 25. ये कौन है respondent number 3, respondent number 1 and 2? Full brother.
He is the brother of respondent number 2.
तो क्या कर रहे थे अब तक?
No risk. We just got the information. Because the prior order was of 16/12.
आपका सारा कहानी ही अबेटमेंट पर है, उसके बाद भी आप लोग इतने नेग्लिजेंट हैं और ऑलरेडी अबेट कर दिया है मैटर। यस, वी हैव टू सी इट फ्रॉम द डेट ऑफ द डेथ and the
But we
appeal
had-
abates automatically.
But we had no information regarding that. We just
एक ही जगह के सब लोग, आपके पास इंफॉर्मेशन नहीं है? हाँ, सेम एड्रेस, आपके पास इंफॉर्मेशन नहीं है? आई विल नॉट बिलीव दिस.
I'm seeking one big time.
सेम एड्रेस में तो हम नहीं मानेंगे कि आपके पास इंफॉर्मेशन नहीं था, एकदम नहीं मानेंगे. Essay number 249 of 2019. The Learned Counsel for the appellant has submitted that respondent number 3 has also expired. In the month of March 2025. He submits that the appellant had no information about his death, but the records of the case show that the address of the appellant and the respondents are one and the same. Apparently, the appeal has abated in connection with respondent number 3. The counsel for the appellant seeks adjournment post on next Thursday
Seeking one
by
big
way of last indulgence. हो गया ना, 1 week मांगे, 1 week दे दिए, हो गया, बात खत्म.
We'll file the IA.
कुछ नहीं, आइए तो हम डिस्कस करने वाले हैं.
We'll file the IA.
I'm telling you, I'll discuss that.
We'll file the IA. We had no information regarding that.
आप कैसे बोल सकते हैं?
Last
आपका एड्रेस सेम है, रेस्पोंडेंट का एड्रेस सेम है, आपको इन्फॉर्मेशन नहीं, आपका पड़ोसी मर गया.
But last-
बहुत द ओनस इज वेरी हेवी ऑन यू
But-
टू से दैट यू डोंट हैव एनी
But
इन्फॉर्मेशन.
the appellate, they had no information. But last order 16/12/2024 का था ये order. उसके बाद अभी 5 फरवरी 2026 को वो लिस्ट में आया.
वो आप एक्सप्लेन करिए, वो हम नहीं जानते, लेकिन आप ये नहीं बोल सकते हैं कि इन्फॉर्मेशन नहीं था आपके पास. पड़ोसी मरने का इन्फॉर्मेशन नहीं है.
But
वेरी गुड, ये लिखिए. कंधा भी दिए होंगे साथ. चलिए.
On the heading for orders from supplementary item 21 FA 124 of 2026.
कितना दिन डिले?
54 days.
ऐसे
The first appeal. ये चूंकि डीसी कोर्ट में फाइल हो गया था.
रेस्पोंडेंट कौन है? रेस्पोंडेंट कौन है? स्टेट.
No state, it's not private. But we have 36.
देखिए आइए नंबर 2414 of 26 has been filed seeking combination of delay. Issue notice to the respondents in the interlocutory application through registered post, नहीं, through speed post. कहाँ के हैं लोग?
देवघर.
Through speed post, for which requisites
और बिहारी प्रोसेस करें तो उसका 36 36
through ordinary process, for which requisites be filed within a period of 2 weeks preemption. Post on 8th of April, awaiting service.
Under heading for admission item 22 CMP 295 of 2008.
Where is the appellant? Petitioner?
number 4 and 6.
Yes? Who are you?
I am a view of my senior in my first project.
So you see adjournment in the restoration application of 2008.
हाँ restoration और
कितना साल के लिए adjourn करना? How many years of adjournment do you want? 5 years?
no ma'am
नहीं, फिर क्या? बताइए, आपको टाइम चाहिए ना?
no ma'am
कितना साल?
restoration of
वही तो 2008 से हो गया 15 साल, अब कितना साल के लिए adjourn करना है?
lordship passes not
सबकी तरफ से अपीयरेंस आ गया?
6 and 4 and Lordship, respondent number 6 में शंकर मुंडा का नाम अपीयर होना चाहिए। ऑर्डर शीट में उनका छूट गया है।
This matter was filed for you, respond number 1 and 3. 1, 2, 3.
Respond number 1 and 2.
1 and 3.
1 and
1, 2, 3.
1, 2, 3. आप किनकी तरफ से हैं?
Respondent number 4 and 6.
4 and 6. और 5 कौन है? Who is 5? Koka Munda? Who is appearing for Koka Munda? कोई फाइल किए है वकालतनामा? Respond number 5 का वकालतनामा तो है, but nobody is appearing. हाँ बताइए, क्या बोल रहे हैं आप क्या बोल रहे हैं?
Lordship, पिछले डेट में अपीयर हुए थे respondent number 5 का अधिवक्ता।
नहीं ठीक है, आज बाकी सब तो अपीयरेंस हो गया ना,
जी।
रेस्टोर कर देते हैं, क्या
Yes,
करेंगे?
Lordship.
ये रेस्टोर कर दे। CNP number 295 of 2008. कोई आइए पेंडिंग है इसमें?
नहीं.
This petition has been filed for restoration of SA number 630 of 2004, which has been dismissed on account of non-compliance of preemptory order dated 21/10/2005, whereby the defects were to be removed within stipulated time. The learned counsel for the petition has referred to the amendments made in the CMP and has submitted that the reason for non-removal of defects is bona fide. As there was talks of compromise between the parties, the matter arises out of partition suit. The learned counsel for the respondents has no objection so far as a prayer for restoration is concerned. Considering the submissions, the time for removal of defect granted by the order dated 21/10/2005 in SA number 630 of 2004 is extended till 20th of March. If the defects are removed, defects in the essay is removed within the stipulated time, office is directed to place the essay before appropriate bench as per roster on 24th of March. CMP is disposed of. उनका अपीयरेंस रिकॉर्ड। आप अपना नाम बताइए, हाँ, नाम लिख के दीजिए।
Under heading for hearing
आप लोग का
and-
मीडिएशन नहीं होगा अब? Is there any possibility of mediation? सुलह मशवरा हो सकता है?
Yes, Lord, severe clients की कुछ बता सकते हैं।
अगला डेट में
Lord,
बताइए।
मेरे पास सेकंड अपील का कॉपी नहीं है।
वकालतनामा डाल दीजिए, सेकेंड अपील का कॉपी मिल जाएगा। आप भी डाल दीजिए ना, अब दोबारा नोटिस होगा। just see.
Under heading for hearing under order 41 rule 11 of CPC item 23 second appeal 50 of 2018.
Yes, appellant.
Yes, this is defended second appeal against the judgment of examination. On last occasion, this case was taken up, Doctor, the dispute arose whether the plot number 387 or 388 belongs to the respondents or
That is not the dispute. The dispute is whether plot number 387 and 388 is a part of the scheduled property of the suit. ये dispute है।
but the
आपको बड़े अच्छे से
during the pendency of the suit, Lordship,
I want to know during the
it is
pendency
a
of
part,
the
it is a part of that. A petition was filed under order 6 rule 17 CPC.
When?
Before the in the title suit number 1983.
that was allowed.
That was allowed.
During final degree preparation.
No.
No.
During the pendency of the title suit.
देखिए, अगर आप ऐसा बोलेंगे ना तो हम रिकॉर्ड मंगाएंगे, उसके बाद इतना कॉस्ट लगाएंगे कि कुछ आप सोच नहीं सकते, क्योंकि both the courts have said that this was not a part of the scheduled property.
नहीं, बाद में तो amendment petition फाइल हुआ।
कब? After the passing of the preliminary decree? Is it permissible under law? You show me one judgment. One judgment. That the schedule of the property can be changed.
It is not permissible.
Then matter ends.
Absolutely right.
Matter ends. फिर क्या बचा?
But Lordship, mechanically issue framed by the London Trial Court, Lordship. Issue framed by the London Trial Court.
Issue से क्या मतलब?
High important, Lordship. Only I will take only 1-2 minutes, Lordship. Lordship, mechanically issue framed by the London Trial Court. Para 7, Lordship. Issue number 5. Is the suit property absolutely recorded in the name of either?
The trial court is issue is not in para 7.
Para 7 of the appellate court judgment it is discussed.
No, I am referring the trial court.
अब trial court judgment. ठीक है,
Page 28, Lordship.
Page 20.
Page 20, para 7.
Yes.
The issue number 5, Lordship.
Yes.
Is the suit property absolutely recorded in the name of either Patra Pasi or Megu Pasi in the Parcha?
ये रोमन 4 है, उसके बाद रोमन 5 है, दोनों में से कौन सा पढ़े?
अच्छा, नहीं, is the suit property was recorded in the name either Patra Pasi or Megu Pasi, Lordship. 4 वाला.
अच्छा.
Wrongly लिखा हुआ है.
ठीक है.
Now, Lordship, may kindly see findings, Lordship. Page 30, Lordship. Issue number 4 and 5. That the
Page 30.
page 30, Lordship.
हाँ.
Issue number 4 and 5. Second paragraph. The plaintiff case is that suit property is absolutely recorded in the name of Patra Pasi, and they were not the party in the title partition suit number 21 of 1993. So the judgment and decree of the title suit partition suit number 21 is not binding on them, whereas the defendant contention is that suit property was recorded in the Megu Pasi, who was the ancestor of the defendant. They are lots of two ancestors. They are all the related to same lordship. One property was recorded in the Megu Sahu and second was Patra Sahu. And now lordship mechanically plain lordship. They admitted that it is a joint property lordship.
Admit करने से क्या होगा? Schedule में नहीं है. I just want to know one thing. The crux of the matter is, उस दिन भी बोले थे, आज फिर से repeat कर. या समझे नहीं, या समझना नहीं चाहते, या कुछ समझिए. अगर मान लीजिए किसी के पास 10 प्रॉपर्टी, ड्यूरिंग द पार्टीशन डीड सूट only 7 properties are included and 3 are left out, and no objection is taken, and nothing happens, the schedule is not amended, तो partition 7 property का होगा कि 10 property का हो जाएगा?
7.
Please.
7.
Then?
Law you will settle law.
तो फिर?
Law you, but I am not sure that whether the amendment petition was filed
Not
during
sure.
the pendency of the suit or at the stage of final.
ये दो concurrent finding and you are not sure? Concurrent finding.
Yes, absolutely.
Then that this property was not a part of the suit property. Matter ends. बताइए इसमें कुछ आपको बोलना है तो बताइए कुछ. Throw some light.
It is well discussed, para 17 and 18 of the appellate court judgment, well discussed that.
पारा 3 में वो एडमिट करने के कितने ज्वाइंट अगर पार्टीशन होगा तो दोनों
को पार्टी भी नहीं बनाया प्रीवियस।
अगर पार्टीशन होगा तो दोनों प्लॉट का पार्टीशन होगा, हमको भी मिलेगा इनको भी मिलेगा।
एक सेकंड, आज इसको नहीं सुनिए, आप इसको बड़े ध्यान से पढ़िए। यू रीड बोथ द जजमेंट्स वेरी केयरफुली, पूरा फुल टेक्स्ट अच्छे से पढ़िए। ठीक है, नेक्स्ट वीक ठीक है। ट्राई टू फिगर आउट इफ देयर इज एनी क्वेश्चन।
ठीक,
आप भी पढ़िए, आपको सुन के ही ऑर्डर करें।
यस।
Let this matter be posted on next Wednesday. Wednesday 18 है? नहीं, Thursday कुछ दिख गया तो इसीलिए हम चुप हो गए।
ठीक,
आप आराम से देखिए।
ठीक।
Under heading for admission, item 31, FA 229 of 2023.
Ms. Apilan?
We are the last one. Fresh notice was issued to respondent on the checked the office copy. It has been personally served. Respondent number.
Okay.
That can be declared to be sufficient.
You have filed your affidavit?
Sorry, Leadership.
Okay, it has been served.
Yes, service report. LCR is not been got.
Why?
Because I had filed an IA for adding the new address for respondent number 3. I am assuming that is the reason. Otherwise, on the first day.
It has not been admitted so far.
No, it is not been. Rising out the partitions.
Is there any
No delays. Respondent number 1 has appeared. It appeared on the last day.
how many respondents are there? 3?
3 respondents.
All of them have appeared.
No, only respondent 1 has filed appearance, 2 and 3 now validly served.
2 and 3 both are valid.
On the last date, 2 was also validly served, 3 fresh orders were passed.
FA number 229 of 2023. The Learned Counsel for the appellant has submitted that. As per the office note, the notice upon respondent number 3 has now been validly served. The Learned Counsel has submitted that. The respondent number 1 has appeared by filing wakalatnama. So far as respondent number 2 is concerned, 1 and 2 दोनों में हैं, दोनों appear हुए हैं।
I had checked the Wakala.
कौशल किशोर सिंह
That is what.
टू का सर्विस रिपोर्ट कहाँ है?
उनका लास्ट क्वार्टर में रिफ्लेक्ट कर रहा है.
Last order is dated 9.
Sorry, last one. That is 29 to 24.
He has referred to the order dated 28 to 24 to submit that it has been recorded therein that in spite of service of notice, nobody had appeared then with respect to respond number 1 and 2. Your IA for this is closed?
Yes, that was allowed. That is for
That is all allowed.
adding the new artist.
The case has not yet been admitted. Admit, call for records from the concerned court. Since respond number 1 and नोटिस तो एडमिट के बाद फिर से जाएगा. एडमिशन के बाद नोटिस. You have to take fresh steps.
For all three.
No, those who have filed वकालतनामा उनका नहीं करेंगे. Since respondent number 1 has already appeared, no notice need be issued. Let notice be issued post admission on respondent number 2 and 3. कहाँ है? एक पटना through speed post.
Who is in Patna and three is in Jamshedpur.
Through speed post, for which requisites be filed within a week. Requisites within a week.
Within 2 weeks करेगा.
Within 2 weeks. Let the records be called for from the concerned court. Post on 8th. Office to track speed post delivery.
जो आइटम 32 में क्रॉस ऑब्जेक्शन है, 33 में एडमिशन के लिए है, तो क्रॉस ऑब्जेक्शन अभी कॉल करेगी.
कौन सा आइटम नंबर?
32
कहाँ से कॉल कर रहे हैं? ऑर्डर 41 टू 11 वाले मैटर्स का टाइम है ना अभी.
को एडमिट करने का
हाँ ठीक है.
ऑर्डर 41 पर
ऑर्डर नंबर केस नंबर कौन सा बोल रहे हैं?
32 में क्रॉस ऑब्जेक्शन सीरियल नंबर
32.
डेली
फर्स्ट अपील है ना, तो एडमिट होगा. इसका क्या करना है? कॉल करिए उसको. 32 एंड 33 बोथ अलग अलग है क्या दोनों?
जी अलग अलग.
एक ही केस से नहीं अराइज करता है. इसका कनेक्टेड अपील कौन सा है क्रॉस ऑब्जेक्शन का? कॉल करिए सर.
Item 33, cross objection item 1 of 26.
You are there in this case? Cross objection?
Let's say serial 33 are there.
32. What is the connected appeal? Appeal number? FA number 7 of 24. The date देखिए. FA number 7 of 24 का डेट बताइए. The appeal has been admitted. By which order? And what is the next date?
Out of list है.
ये FA number बताइए.
FA number
207 of
24.
24. Admit हो चुका है.
Yes.
Out of list है.
जी.
कौन से डेट पर एडमिट हुआ?
29/1/2026.
29/1/26. And what is the next date? What is the next date?
डेट नहीं दी. एडमिट होने के बाद कोई डेट नहीं.
मेरा ऑर्डर होगा तो डेट के बिना कैसे ऑर्डर होगा?
मैं लेट सी कोर्ट से.
उस वक्त तो फर्स्ट अपील मेरे पास है ना. 26 का ऑर्डर है.
ये 24 का ऑर्डर है. 1
तो 24 का CO number 1 of 2026. Counsel for the cross objector is present. She submits that the cross objection is in relation to first appeal number 207 of 2024, which has already been admitted by order dated 29/1/2024. However, no date has been fixed in the said case. She submits that this cross objection be admitted. Admit. Issue notice to the respondent. उन लोगों का वकील कौन है?
फर्स्ट अपील रिसीव. और मिस्टर इंद्रजीत सिन्हा, अजय कुमार साहब.
इससे इंद्रजीत सिन्हा कहाँ है? उनके चेंबर पे. इधर आइए. आप हैं उनके चेंबर में? अरे भाई, सीनियर से आप कभी नाता टूटता है क्या किसी का? कोई बात. आपका एक फर्स्ट अपील आपके चेंबर से फाइल हुआ था 24 में. इसको कल रखते हैं, कल उन्हीं से करा देंगे ना. Mr. Sani, I am posting the first appeal tomorrow along with this cross objection. They will accept notice.
Yes, it will be better.
That will be better. Unnecessary क्या करना?
Yes.
Put this case tomorrow along with first appeal number 207 of 20. चलिए, next case.
I communicate.
नोटिस तो नहीं होगा.
कुछ नहीं होगा.
tomorrow से.
कल दोनों को एडमिट कर देंगे ना एक साथ. वो तो एडमिट है, इसको एडमिट करेंगे. रिकॉर्ड आ ही गया होगा.
FF item 33 FF 112 of 26.
This was an applicant has filed a claim for us. My claim has been dismissed for us.
The complaint has been dismissed.
So was my after trial the suit has been dismissed. Was the respondent BCCL is the respondent and the state of Jharkhand is respondent.
तो कॉपी सर्व किए हैं.
Yes, for us that's not the cause.
स्टेट ऑफ झारखंड को तो सर्व किए हैं. व्हाट अबाउट BCCL?
My name is the chairman for this.
कौन? Who is for BCCL?
My seniors is
A.K. Das. He appears for BCCL also.
I was in some of the cases Mr. Das also has.
BCCL का वकालतनामा भी है. Okay. It requires formal admission.
So I'm
It requires formal admission.
yes.
Okay, first appeal number 112 of 26. Counsel for the appellant is present.
State.
Counsel for the state is also present. Nobody appears on behalf of respondent BCCL, although they have entered appearance filing wakalatnama. Admit. Call for records from the concerned court. No notice need be issued at the as the
It's no private party, it's state.
as there is no private party. Let the records be called for from the concerned court. Communication. Post on 8th April.
Heading for hearing under 4111, item 34, second appeal 61 of 2013.
Yes, defendant second appeal. In five, and widow and daughter, they are the plaintiffs. And they have filed a suit for declaration of title, confirmation of possession, and alternative not recovery of possession.
You are the defendant?
I am the defendant. But it is the case of the plaintiff.
Lost in both the bills?
Lost in both. But it is the case of the plaintiff that Lord Udaray Manji was the owner of the property. He died leaving widow and a daughter. And what I am claiming to be the nephew of Udaray Manji. Because we are Santhal, guided by the custom of God. And the Lordship is aware, in Santhal, the women have a limited right of maintenance. And in the plain, there is no averment as such that they are now, the plaintiffs are now governed by Hindu and they are Hinduized, and now in terms of section 2 subclause 2, they will not be governed by their customary law. There is no averment in the plain as such. But notice in the written statement, initially filed, there was one paragraph which says, the parties are governed by Nitakshara School of Hindu law, although another written statement was filed saying that we are governed by customary law, and another defendant filed a written statement in which the defendant has said that we are governed by customary law. The trial court, both the courts decreed the suit only on the ground that since defendants have admitted in one of their written statements that the parties are governed by Hindu law, therefore customary law will not come.
Did the plaintiff say in the plaint that they are governed?
Absolutely. I will just show the plaintiff.
And the plaintiff asserted that they are governed by which law?
Customary law.
They asserted?
Yes. You not to see the plaintiff itself. What must have? You may see not the plaintiff, very short note, few paragraphs only. That the plaintiffs number 1 and 2 are the mother and daughter in relation, and except them there is no one in their family. That late Udaray Manji was the husband of plaintiff number 1 and 2. The deceased Udaray Manji was sole and absolute owner of removal property. That the plaintiff inherited the estate of the deceased Udaray Manji by succession and enjoying the said scheduled property absolutely without any interference. That the plaintiff number 2 husband died and plaintiff number 2 is living with her mother. That late Udaray Manji has one brother, and so and so. Note, may kindly see note this paragraph.
You read 7 also.
Yes. As the defendant inherited the estate of late Ramraj Manji on succession as only survivor, and the plaintiff inherited to the estate of Udaray Manji. But we are sons of Ramraj. Udaray and Ramraj were brothers. Now note see 8. That the said deceased Udaray Manji enjoyed the scheduled removal property during his lifetime, and the record of right issued by settlement officer so and so shows possession and ownership of so and so. That the said property situated in Mohalla so and so is within jurisdiction of this court presently occupied. The defendant has no right title or interest over the said scheduled property, as the plaintiff are absolute owners and the defendant with malified intention motive to grab. So now we want to take note paragraph 30. The defendant falsely claims the locality inherits the property of late Udaray, but 17 year old. As the plaintiff and widow, the plaintiffs are widow and illiterate tribal women, and the defendants taking the advantage of weakness of the plaintiff trying to dispossess the plaintiff with malified intention to grab their property. Paragraph 20 notes that the plaintiffs are by caste Santhal of Adivasi community and poor and indigent. So absolutely no averment that they have turned into Hindus, they are Hinduized, and now therefore they are not governed by the Santhal. Because it is custom, it is prevalent over all the above laws. So but once the plaintiff itself does not.
Customary law of Santhal is same for the entire state of Jharkhand.
Also,
Is it same for the entire state of Jharkhand?
but in different castes, there are different
In
customs.
different pockets, there are different customs.
Yes. So so far as Santhal is concerned, but both the court says कि since defendant in one paragraph has admitted in the written statement, therefore now you cannot back out from that, and therefore the suit have been taken.
Defendant admitted what?
Defendant said that we are governed by Hindu law, Hindu Mitaksha School of Hindu law. That is one written statement in paragraph 19. And other written statement, not specifically it says that we are governed by customary law of inheritance, and the widow and the daughter have no right, she only have a maintenance right. And there is one more written statement by other set of defendants in which they also say that we are governed by customary law. But
And the suit has been decreed in favor of the
plaintiff,
the widow and the daughter.
widow and the daughter.
So you must have led the evidence on custom. Did you?
Not, I have not led any evidence of custom, but not this custom.
Custom is required to be proved.
But unless and until the plaintiff pleads that they have converted into Hindu.
No, not necessarily.
But
Even
then,
for the custom,
Yes.
even in order to exclude women,
yes,
you have to plead and prove the custom. Not only the tribe you belong to, but also the area to which it is specific. Because the entire Santhal area in Jharkhand does not follow the same custom.
but it is unless and until there is a pleading by the plaintiff that we have converted and
Not
we are not governed.
necessarily. It is not necessary. It is not necessary that they will have to plead that they have got converted or Hinduized. There is no standard or established law. The Santals are completely excluding women.
But
That is, there is no such law.
Therefore, I say that your lordship is aware हर जमा वाला इतना cases क्यों होता है SPT Act and because of
नहीं
this
नहीं क्यों
reason
होता देखिए ये
because of this reason only कि widow have no
एक
right.
जजमेंट हम किए थे वो जजमेंट अपहोल्ड हो गया सुप्रीम कोर्ट से। हम यही बोल रहे थे इवन इन दीज केसेस किस पॉकेट में क्या कस्टम है इज रिक्वायर्ड टू बी प्रूव्ड इन ऑर्डर टू प्लीड इन ऑर्डर टू एक्सक्लूड women from their
But therefore, once we have said in our written statement that according to our custom, only the male will get the property and the plaintiffs are not entitled. The appellate court frames an issue on that and decides only going into the.
You see, the once you take a stand in the written statement
Yes.
that females are excluded from inheriting,
Yes.
you have to prove it. Where is the proof of the custom?
But I have to prove which is admitted by them that they
Written
are Adivasi or
statement
Santhal
एक से
community.
भाई रिटन स्टेटमेंट में ये तो एडमिटेड है कि संथाल हैं
हाँ.
ये कहाँ एडमिटेड है that they are excluded
So not once we have said in the written statement
तो आप
specifically.
रिटन स्टेटमेंट में जब आप स्पेसिफिकली बोलेंगे तो प्रूफ भी तो आप ही को करना होगा ना
Therefore, I say not. It is an admission on the part of the
एडमिशन रिटन स्टेटमेंट का
plaintiff.
स्टेटमेंट कैसे एडमिशन होगा
Plaintiff themselves
plaintiff
also.
say that they are santals
Yes, they are
do
Santhals.
they say that they are excluded
But therefore, I say not. Once the plaintiff themselves admits this that they are Santhals, and defendant also says that they are Santhals, so it is admission of the plaintiff also that they are Santhals. Now let
admission
us-
that they are santals
Yes. So let us see not if they are Santhals, whether they can claim the property as a matter of right in view of the fact that they are Santhals and there is an admission of the plaintiff. Specifically when
is there any judgment which says that all the santals
yes,
in the entire community of santals they are completely excluded
but that to judgment तो I have to
नहीं है ना हो सकता है
No, but
ना है ना हो सकता है the reason is there is a reason for that because even in gangster settlement
Yes.
it has come that different pockets have different customs it is not uniform so
But-
therefore wherever you belong to you have to plead you have to prove the custom उसके बिना आपका customary right
नोट मेरा ये तो नोट इतना तो एडमिटेड है कि हाँ अगर हम संथाल है and if there is no pleading by the plaintiff that we have
अरे
turned
भाई
into Hindu.
admitted
हाँ.
that you are santhal
Yes.
but there is no admission that
The
women
lordship is saying that there is no proof of the custom
there is no
No,
proof of the custom
to disentitle.
yes
So not let us
once you take a stand
yes.
that women is excluded you have to prove it by evidence
So let us see not the finding of the yes. But this is
पहले ट्रायल कोर्ट देखते हैं.
हाँ,
कॉन्करेंट है.
concurrent. But ट्रायल कोर्ट में तो ये इशू ही फ्रेम नहीं किया गया, लेकिन फिर भी आंसर किया. अपीलेट कोर्ट में ये इशू फ्रेम है.
पहले ट्रायल कोर्ट देखते हैं.
But issues are at internal page 4 of the trial court judgment. But issue number 5,
एक
6 and
सेकेंड, आपने
7.
ट्रायल कोर्ट जजमेंट ही नहीं दी. ये इनको दे दीजिए, जरा वापस कर दीजिए. अपीलेट कोर्ट जजमेंट से आपने अपील फाइल किया था ना.
हाँ.
उसके बाद ट्रायल कोर्ट का जजमेंट किधर? देखिए रिकॉर्ड पर. बताइए. इशू बताइए.
Yes. Trial court, Your Honor. Yes. But trial court issue number 5, 6 and 7 have been there. Whether the plaintiff is entitled for a degree of declaration that they are bona fide owner and title holders of the disputed property. Whether the plaintiff is entitled for a degree of confirmation of possession and in the alternative degree of recovery of possession. Whether the plaintiff is entitled for any other degree. That have been taken note of in the foregoing paragraph. And Your Lordship may see notes. Paragraph, running internal page 7 notes from bottom. 7th line from bottom notes in the middle. From
एक चीज
page-
और हम जानना चाहते हैं, आपका रिटन स्टेटमेंट का अमेंडमेंट वाज अलाउड?
Yes.
You deleted that.
No, Lord, there was no amendment. It was an additional written statement.
ऐसे कैसे होगा?
So,
कॉन्फ्लिक्टिंग.
this was, Lord, there were 3 written statements on the record.
कॉन्फ्लिक्टिंग तो नहीं हो सकता.
First is the first written statement, then there is additional written statement, and then there is a written statement by the other set of defendants.
That's right. But conflicting तो नहीं हो सकता ना. Additional written statement में you cannot take a contrary stand. Conflicting.
Conflicting.
Then you
That
can amend the written statement.
Yes, I can amend it.
But you can, in additional written statement, you cannot take a conflicting stand.
Yes.
This is what you have done.
Therefore, Lord, I say this, that the plaintiff has to prove his own case. It is not the weakness of the defendant, or not if I do something which is against the law, that cannot help the plaintiff in getting a degree.
That's right.
So that is well settled in our law, that the plaintiff cannot
आपने
take
अपना कास्ट सर्टिफिकेट एग्जिबिट कराया.
Sorry, Lord.
कास्ट सर्टिफिकेट एग्जिबिट कराया.
Lord, exhibit तो इसमें खाली खतियान किए हैं और ऐसा कुछ.
अच्छा पढ़िए, फाइंडिंग पढ़िए, देखते हैं.
Lord, paragraph internal page 7, Lord. From bottom, Lord, 7th line, from page user.
No, you read it from the top. Law referred from the side of the
Law referred from the side of the plaintiff, 1994 1 PLDR page so and so, 2004 1 JCR and 2001 PLDR page 30. As per the ruling filed by the plaintiff, since the defendant have pleaded about customary law tribal, so he has to prove the case. And in the instant case, the defendant failed to prove the custom as per the ruling of the Honorable Apex Court below are the absolute owners of the property of the deceased husband if they have left the tribal custom and become Hindu. As per the ruling filed by the defendant have right to take inconsistent plea in the written statement and can deny any plea alternatively for 2 different cases. So and so ruling cannot make a new case made out on the pleadings. 1971 Madras 58C plaintiff has to stand on his own legs and he cannot rely on the alleged case by defendant. The plaintiff has to prove the fact that they have been sufficiently Hinduized, and if they fail to prove this fact, the Hindu Succession Act will not be applicable in the case as the customary law of alphabetic succession of tribal law shall remain operative. 1991, 1 PLDR, page 199, separation in mesh and cultivation is not proof of partition by meets and bound. And if Kabjewari shown in revenue report of the right is relied upon, the rent receipt should be taken on the same right. AIL 1977, Patna 201, any property possessed by a female Hindu must be either constructive or physical. 1991 PLGR, page 605. The applicability of Hindu Succession Act 1957 with respect to members of scheduled tribe. Custom has to be pleaded and proved that they are fluently Hinduized. So, the user of the record of right exhibit B, it appears that plaintiff and defendant have equal share in the respect of Khata number 92, 93, 94. Now, question comes before the court whether the widow of a deceased Budhari and his daughter will inherit the property of Budhari or not. From the user of Khatiyan of Khata number so and so, it is clear and evident that the land has been recorded in the name of Budhari Saw, and after that, it is named Sauri Soren plaintiff number 1. From the user of exhibit B, it also appears that name of Sauri Saw has been shown as a successor in the document along with defendant. From the user of the original written statement, it appears that the defendant have accepted that they are governed by Mitaksara School of Legal Law, but they have filed additional written statement. They have taken a U-turn from their earlier statement and that they are governed by Mitaksara School of Hindu Law and pleaded in their additional written statement that they are governed by customary tribal law, which excludes the female relative of the deceased male ancestor from the right of succession as per tribal law. So the plaintiff are not entitled to inherit the property of late Budhari. It is true that the defendant has every right to take alternative plea in the written statement, but they cannot retract from the admission earlier made by them by their subsequent pleading. If they do so for taking away the important right of other side, excluded by their admission, then law of stoppage will come into play and they cannot be allowed to do so. In the instance suit, the original pleading, the defendant have admitted that this fact that they are being governed by Mitaksara School of Hindu Law, so burden of plaintiff to prove that they have been sufficiently wise becomes unnecessary, especially in light of the admission made by the defendant, and defendant cannot be allowed to retract from the earlier statement by filing their additional written statement after though. So this fact has been fully proved by admission of defendant that plaintiff and defendant are being governed by Mitaksara School of Hindu Law, though they are tribal by caste. Oath against oath have no value. Plaintiff has stated in their evidence that they have been sufficiently Hinduized, and defendant in their evidence stated that they are following the customary law of tribal. This question becomes unwarranted whether the property of plaintiff or the defendant was joint or separate, because if they are governed by Mitaksara School of Hindu Law, widow and daughter being class 1 heir will inherit the state of the last male ancestor fully, because provision of Hindu Succession Act shall apply. So in the instance suit, the plaintiff will get the share of Budhari Mandhi because Hindu Succession Act has given a death blow to the law of survivorship. The female heirs are representing the state of the last deceased male, so the property will devolve upon the nephew and other male agnates of Budhari. Rather, it will inherit by the widow and daughter of Budhari. So, defendant number 2 and 3 have pleaded the fact they are being governed by customary tribal law, but they have not adduced any evidence in support of the pleading. So, the pleading of defendant number 1 and 2, in absence of any evidence, becomes useless and ineffective. Ruling by the parties are not relevant, comes to the conclusion that plaintiff are entitled. Therefore, only on the basis of admission. And would also say that plaintiff have stated in their evidence. So, not this also, that once the plaintiff has not pleaded in their claim that they have become Hindu. So, therefore, this goes that it is an evidence beyond pleading. And only on this, and ignoring the fact that there was another set of written statement in which it has been specifically stated that they are governed by customary law and the females are not entitled. But I can understand if I have given a written statement and I try to retract or take a absolutely not U-turn or contradictory stand. That is not permissible. But there was another written statement also which says that they are governed by the customary law. So that has not been brought directly.
But admittedly, there is no evidence of any custom.
There is no evidence of any custom. There is no evidence of any custom, but not the what.
You see, even in cases where a question of law may arise, it may not be a substantial question. Because there is no evidence on custom. क्या decide करेंगे हम?
Once it is, I submit that once.
There is a marked difference between a question of law and a substantial question of law.
There is no doubt on that.
When there is no evidence,
But
and you admittedly there is no evidence on record.
But there is no documentary evidence. We have
No.
laid evidence and said that
Late evidence, what evidence?
we are governed by customary law. They have crossed us. That is, they are not in the trial court.
Governed by customary law is one thing.
Yes.
Exclusion is another thing. Exclusion is also required to be proved by evidence. These are two different things altogether. Being governed by customary law
So not.
and there is exclusion
No,
are
if
two different things.
But if I say this, let us take this. If I am governed by a customary law and the customary law is such that it is excluding the female from inheritance, then what it is sufficient if the parties admit this that we are governed by customary law. The customary law is as such. If I am
This is not a general statement applicable to every area of the state of Jharkhand. ऐसा कुछ नहीं है.
But
नहीं इसमें हम सब्सटेंशियल क्वेश्चन अपना नहीं बनाएंगे.
But ये तो कम से कम फ्रेम होना चाहिए उसकी in view of this कि if there is a written statement and in the plate there is no statement as such, whether or not that will disentitle the plaintiff from seeking the declaration.
You filed a written statement that you are governed by Mithakshara's rule.
Yes.
Right?
Yes.
You have not filed a written statement that you are otherwise Hindu. That is not a written statement.
But we have filed a written statement initially that we are governed by Mithakshara's rule of Hindu. There is additional written statement. Let me say not that cannot be because we are taking contradictory statement. But there is another written statement by another set of defendants which specifically says that we are governed by customary law. So once they are governed by customary law, then definitely that has a bearing. Let me assume that one set of defendant admits the case of the plaintiff. The another set of defendant is taking a stand that we are governed by a customary law, so that requires a consideration by the court. The court only says if since one of the defendants have taken a stand that you are governed by Hindu law and not by custom, therefore another written statement has been negated. It has not been looked into. I cannot take a different stand or I admit this. But another written statement in which it was the first written statement by them, so that stand was their notes. So
who were those defendants?
Yes, Lord, I will show the written statement itself. But this is the first written statement, second and third. I have flag mark those.
This is your written statement.
Yes, in this we have admitted paragraph 19. Then your second flag you will also see.
This is second written statement of?
Is by additional written statement.
By
By same
different
party, paragraph 8 notes of that. In which
This
we
is
have
of no
taken
use.
no use.
What about defendant number? Who are defendant number 1 and 2?
Sorry, what?
Who are this written statement filed on behalf of substituted legal heirs?
But that is a written statement where there is no contradictory stand. They are not taking a U-turn. That is paragraph 8.
No, where is the written statement of the other defendant you say that they admitted?
Yes, there are 3 written statements that are flagged.
This is of the legal heirs.
So not legal heirs can
Legal heirs cannot take a different stand.
not see paragraph 8 of this. Paragraph 8 of this. The last one.
Yes.
The statements made in paragraph 4A, amended para after the death of ancestors of Kalu Manji, his two sons Pudrai Manji and Ramlal Manji partitioned the ancestral land amicably and absolutely was baseless and denied by the ancient defendant. As a matter of fact, after the death of their father, Pudrai Manji and Ramlal Manji were enjoined cultivation and enjoyment of the land in their lifetime and continued cultivation of paddy of the suit land over the other lands of their father. Of course, some of these lands were separately cultivated by two brothers. As a matter of fact, the parties are guided by the customary rule of the matter of inheritance and succession and marriage, and they never adopted or followed any rule of Hinduism. And according to their caste, custom and married daughters are excluded. from inheritance of
See,
their father's
this is
property.
being taken by the substituted
So, but the
respondents.
court does not deal with this. Court only says you have filed an additional written statement.
Additional written statement by original defendant एक additional written statement file करके चला गया, ठीक है? उसके बाद उसके legal heirs will take a contrary stand.
But
How is it permissible?
But the lordship will see.
They are bound by the written statement filed by the original defendant.
They are bound. But here your lordship will see not the plaintiff themselves admits this.
We'll see that.
The plaintiff themselves
We'll
admits
see
this.
that. We'll see.
So, but therefore I say not at least one
Not a
opportunity
case.
to contest.
No.
Because your lordship will see not
No.
जहाँ plaintiff का plaint में कोई pleading ही नहीं है.
कोई बात नहीं. लिखिए, आपका सारा सबमिशन लिख के डिसाइड करेंगे. essay number 61 दीजिए, प्लेन दीजिए. Essay number 61 of 2013. This appeal has been filed against a judgment dated 30th January 2013 within bracket decree dated 20/2/2013 bracket rules passed by learned District Judge Roman 3 East Singhbhum, Jamshedpur. Entitled Appeal number 34 of 2007, confirming the judgment dated 24/4/2007 within bracket decree dated 8/5/2007, passed by learned Sub-Judge Roman 6. The learned counsel for the appellant has submitted that though both the learned courts have the suit was decreed. The suit was decreed, which was filed by the widow and daughter of the recorded tenant. And the first appeal has been dismissed. But a substantial question of law arises for consideration in this case. The learned counsel submits that the plaintiff had admitted that they belong to the tribe called Santhal in their plaint, and they had never taken a plea that they are sufficiently Hinduized and consequently they are governed by Hindu Succession Act. But the learned courts have recorded a finding that the courts have recorded a finding on the admission of the defendants in their original written statement that the parties are governed by, wherein they had stated that the parties are governed by Mitakshara school of Hindu law. The learned counsel submits that though the written statement was not amended, but an additional written statement was filed. तो प्लेंट अमेंड हुआ था?
हाँ, प्लेंट अमेंड हुआ था।
अमेंड करके क्या हुआ था?
तो प्लेंट अमेंड का तुम
What was the plea in the amended plaint?
इसके बारे में कुछ नहीं, बट की जो
कहाँ
सक्सेशन
है
के
आपका
बारे में
amended amendment?
paragraph 4 में that after death of so and so this was amended.
Para 4 of the plaint.
Yes. It says that after death of Kalmi Mandi, there was amicable partition between the two sons of Puthalai Mandi and Raghulal Mandi.
The learned counsel submits that the plaint was amended and additional written statement was filed. And in the additional written statement, a plea was taken that the parties are governed by customary law. कहाँ लिया additional written statement?
Yes. वो but this is in paragraph 8, no, the additional.
And according to caste custom, the plaintiffs are not entitled to share in the suit property. And they never succeeded to the interest of the recorded tenant. उसमें भी exclusion का बात नहीं है.
Five and 6. I'm sorry.
It has also been asserted in the additional written statement that the interest in the joint family property devolved upon the brother of the recorded tenant by way of survivorship according to their caste custom. The females are excluded from inheritance. And they are only entitled for maintenance. The learned counsel submits that the additional written statement after the substitution of the concerned deceased defendant, in the written statement filed by their legal heir, similar averment was made. The learned counsel submits that since the plaintiff did not raise a plea that they are governed by, they are sufficiently Hinduized. Therefore, the parties were to be governed by customary law, and the written statement of the defendant stating that they are governed by Mitakshara law is of no consequence. He submits that if the tribals are sufficiently Hinduized, then they can be governed by Mitakshara law and inheritance can be claimed by virtue of Hindu Succession Act. But in absence of any such plea, the Hindu Succession Act, in absence of any such plea by the plaintiff, the Hindu Succession Act could not be applied.
Just one more small action. That initial written statement was filed by defendant number 1. Additional was filed by him.
By all the defendants. आप देखिए defendants करके
डिपेंडेंट का टेन रोड, लेकिन उसमें कहीं ये स्टेटमेंट नहीं है ऑथराइजिंग ऑल डिपेंडेंट्स
इसका क्या मतलब है?
बट बिकॉज
इस
देयर
सब
इज
चीज का कोई मतलब नहीं है।
एंड 2 और 3 का नोट अलग डब्ल्यूएस है।
एक्स पार्टी कर देते हैं 2 and 3। एक्स पार्टी था प्रोसीडिंग,
नहीं, एक्स पार्टी नहीं था, मतलब जजमेंट में तो ऐसा नहीं है।
ठीक। The learned counsel has placed the plain and written statement during the course of hearing. Plaint में कहीं नहीं है that they are governed by customary law.
बट प्लेट में जो है,
There is no such statement in the plaint that they are governed by customary law. There is only
They
a
say
statement that they are
that
tribals.
they are tribal, Article 17, and then they say that the plaintiffs are by caste Santhal of Adivasi community and poor and indigent person. This
That's
is
right.
what they say, Article 17 and 20.
However, from the plaint, the learned counsel for the applicant could not point out any statement made in the plaint that the parties are governed by customary law. Rather, there is only a statement that the parties belong to. No, there is only a statement that the plaintiffs are tribal women. संथाल भी कहीं नहीं लिखा है.
Santhal is not, Article 20.
And that the plaintiffs are by caste Santhal.
Santhal of Adivasi community. This is what they say.
Santhal of Adivasi community. Second half में दिखाएंगे इसको. I complete it in the second half. I need to rise. जजमेंट कंफर्म होकर आया है सुप्रीम कोर्ट से, उनको पता होगा. अभी 5 जजमेंट्स आए ना कंफर्म होकर, उसमें से एक ट्राइबल कस्टमरी लॉ का वो जजमेंट